We'll hear argument next in Case 13-7211, Jennings versus Stevens. Mr. Schaefer.
Mr. Chief Justice, and may it please the Court, 90 years ago this Court held in American Railway that an appellee need not cross-appeal to raise an argument in support of the judgment that does not seek to enlarge his rights. Petitioner, who prevailed on an ineffective assistance of counsel claim in the district court, did not have to cross-appeal here for two reasons. First, he did not seek more relief than the new punishment hearing granted to him in the judgment. Second, he raised an argument that the district court rejected as an alternate basis to affirm the judgment. And if he did not need to cross-appeal, he did not need a COA.
I don't know if this is a new argument or a new issue. And the reason I raise that is, when the judgment issued here by the district court, it specified two errors that had occurred and basically told the state court, fix those two, or you have to release the defendant. Let's assume they fixed those two, and then could you come back and say release them anyway because they didn't fix the third that I lost on?
No, not under those circumstances.
So how is it not more relief?
I beg your pardon?
How is it not more relief or different relief?
Because the single error is that he was denied the effective assistance of counsel. That is a single claim, and it was based on three allegations of deficient performance.
Well, now, wait a minute. We don't evaluate whether you had good counsel or bad counsel. You may have Clarence Darrow and still be denied effective assistance of counsel if Clarence Darrow makes one mistake. I mean, when we find that there has been ineffective assistance of counsel, I think that means counsel failed to do one thing that he should have done. But there's no such general finding that counsel was in gross ineffective. You're describing it as though that's what the finding is. That's not what we hold when we find ineffective assistance of counsel. We find that this particular counsel made this mistake. That's it.
Well, let's take that a step further. What the court does to analyze an IAC claim is to first isolate the errors of counsel. It could be one, it could be 100. It doesn't matter. You accumulate them and consider them together to determine prejudice. If the deficiencies in performance constitutes sufficient prejudice to undermine confidence in the verdict, then counsel was constitutionally ineffective, not because of A, B, C, or D, but because the totality of his representation did not meet the constitutional standard. So it's not a matter of fixing any particular error of counsel. And that's where I believe the State's position is a little awry, because a federal court judgment in a habeas case is different than a direct appeal judgment. On a direct appeal judgment, the court tells the district court, we're sending the case back to you, do A, B, C, and D, or don't do X, Y, and Z. A federal habeas judgment is a lawsuit against the warden, having to do with the body of the prisoner. The federal court doesn't have authority to tell the state to do or not do any particular thing. The effect of the federal court judgment is to basically say, release the prisoner unless within, in our case, 120 days, you resentence him to life, or you give him a new punishment hearing.
Would your argument be the same if all of the claims in this case were not ineffective assistance of counsel claims? So let's take an example that's in the briefs.
Sure.
Where there's an ineffective assistance there's a ineffective assistance of counsel claim and there's a coerced confession claim. And so the petitioner wins on the ineffective assistance of counsel claim, loses in the district court on the coerced confession claim. The judgment is that he's entitled to resentencing, or let's say it's resentencing due to the ineffective assistance of counsel. But there will not be the opportunity to exclude the coerced confession. So does your argument apply in that situation as well?
Assuming the coerced confession involves the punishment phase as opposed to the guilt
phase. The same
phase,
phase, yes.
Okay. I think that's a situation where the state has a decent argument that because it's a different claim that would perhaps entitle you to more relief under the judgment. That is, not just a new punishment hearing, but a new punishment hearing without the unconstitutional confession. That on the state of the law today, I would file a cross appeal and move for a COA on a separate claim, because I think that would be Pfeiffer, Alexander, El Paso Natural Gas, where you're seeking to modify the judgment and obtain more relief than it would be American Railway.
Why is you say that? Go ahead. Sorry.
Just to follow up on that. If you say that, could not the same situation arise with respect to different ineffective assistance of counsel claims? Let's say that, in this case, you won on your Spisak claim, things that were said during the closing. You lost on the Wiggins claim. Let's say the Wiggins claim was that there was money available from the state to hire experts, but the attorney didn't apply for the money, didn't do an investigation. That was ineffective assistance of counsel. So if you win on the Spisak claim, you'll get a new sentencing hearing, presumably free from the errors in the closing, but you won't get the opportunity to go back and do the time or the money to do the investigation.
I would respectfully disagree with that, because if you get a new sentencing hearing, you get to do whatever you want to do at the new sentencing hearing. And for our purposes, if you now know in federal court that the lawyer didn't investigate mental history and discover X, Y, and Z, you now know it.
But on remand, they say, well, you lost that claim.
No.
You lost it, so there's no need for more money, there's no need for more time. Let's do it over with but with a proper closing.
And that's the thing. The federal habeas judgment cannot direct the state court what to do or not do at a retrial. All it can do is tell them, we're releasing this person unless the constitutional error is fixed.
Well, that's not true. It can tell them what to do. The basis on which the conviction was set aside cannot be repeated by the state court. You're saying that the state court is free to make the same mistake again?
Well, it's actually not me saying, it's this court's opinions have said that on a federal habeas judgment does not decide what a state court may do or not do on remand. We just direct them to fix the constitutional error. We don't tell them how to do it.
Well, once you say we direct them to fix the constitutional error, that is something they have to do on remand, isn't it?
Or the federal court will
fix that constitutional error.
Correct.
But this other constitutional error, which we didn't rule on in the habeas thing, they don't have to fix. It's up to them.
But let's remember, in an IAC claim, it's different than a freestanding admission or exclusion of evidence claim, because a federal court habeas judgment cannot, for example, in this case, the state says, we sought to enlarge our rights under the judgment by asking the federal court to order the state to fix any closing argument error and require a new trial free of this error. We didn't ask that. We could not have asked that. A federal court cannot order a state court to fix any error of defense counsel or tell defense counsel how to try the case, what to offer, what not to offer, what arguments to make. All the court can do is provide a remedy for the petitioner if he does not have effective counsel at the retrial.
And that remedy is a new trial. Or what if one claim is the ineffective assistance and the other claim is a violation of the confrontation clause? And when you go back, they can repeat the error or they can choose not to call their witness. Either way. And it would seem to me that if you didn't file a cross appeal, that the federal court decision would be an advisory opinion on the confrontation clause.
And so in that circumstance, if you were seeking additional relief, i.e. keep out the constitutional admission of evidence, then in that situation, I would file a cross appeal and move for a COA, because I would be seeking to enlarge my rights under the judgment. The judgment that we got here didn't really give us anything more than the Constitution gives any citizen the day he walks into a courtroom, which is the right to a trial with the effective assistance of counsel.
No. The right to a trial that did not have this failure of counsel, this particular failure. You're not entitled to competent counsel. You're entitled to counsel who doesn't make a mistake. He could be the dumbest counsel around, so long as he doesn't make a mistake. And he could be the smartest around. And if he does make a mistake, that's ineffective assistance of counsel.
Respectfully, it's not by itself. The mistakes may be mistakes, but unless the totality of those mistakes constitute sufficient prejudice to undermine confidence in the verdict.
Well, was that an issue here? I mean, looking at the blue brief and the red brief, it seemed to me that the issues here have turned on a mistake. How many mistakes are there? It wasn't a question of prejudice. That is, the lower court said even if you're right, and they thought you were right, that these two errors in failing to investigate the background created prejudice. So I don't think there was an argument on appeal about whether there was enough prejudice. It was a question of, was this a mistake? Am I right or not?
Well, my position on appeal was I'm
just saying, was there an argument about that? Did they disagree about that?
I think the State certainly disagreed with.
Did they? And they argued that before the court. They said even if they said the issue before the Fifth Circuit is whether altogether these three things amount to prejudice, because our view of the State's view was, all right, even if there were errors here, it didn't amount to prejudice.
What they basically said is that the district court didn't defer to the State court findings and conclusions regarding those matters. So, but let's play the State's argument out to its logical conclusion. Under their theory, let's assume the same thing happened to the district court. We win on A and B, we lose on C, and they say, we're not going to appeal. Go back to State court, we'll give you a trial, you can introduce the evidence of alleged mental deficits and disadvantaged background. We'll give you a chance to save your guy's life by laying it off to a jury and letting them decide.
Just clarify, that everything that you're arguing rides on or treating ineffective assistance of counsel as one claim rather than ineffective assistance of counsel, confrontation clause, some other violation. If we don't buy your argument that ineffective assistance of counsel is one monolithic claim, and we think the division between what they're calling the Wiggins error and that those are two different claims, you would lose if that.
I disagree. I don't think you even need to reach the issue of this IAC one claim or not. It's here because they've split my claim into thirds by saying I made three claims instead of one. I can still win under a pure interpretation of American Railway because I am not seeking greater relief than what I got in the judgment, which is a new punishment hearing.
Would you agree that to include all of the counsel's errors is important to show the substantiality of the error?
And that's what I did in the Fifth Circuit, was say, look.
All right. Would you agree that goes to show how substantial the incompetence was?
The combined effect relates to the prejudice inquiry, but of course one alone can be sufficiently prejudicial.
Mr. Oldham?
Mr. Chief Justice, and may it please the Court, it's now common ground that petitioner would need to cross-appeal to add some conditions to a conditional release order issued by the district court. The only question in this case now is whether the particular condition requested by this particular petitioner was necessary or sufficient to add to the conditional release order. And we think that it was. We think that this particular condition, the SPSAC error, was a meaningful condition and it necessitated a cross-appeal for two reasons. First, if petitioner had cross-appealed and prevailed on the SPSAC claim, the State would have been obligated to fix that error, to cure that error, upon pain of immediate release of the prisoner. And that is a dramatically expanded form of relief that would necessitate a cross-appeal.
How would you do that? How would you cure the SPSAC error?
Well, there are many ways that both the State and the defense the prosecution, the defense, and the State court could cure the SPSAC error. It starts with the enunciation of the standard from the federal district court as to exactly what the Sixth Amendment requires of a closing argument, which then guides both the prosecution.
The SPSAC error is something that the lawyer said in closing argument. You're going to have a new trial, right? Well, presumably, the lawyer may say the same thing, or the new lawyer may say the exact same thing, or he may not. It seems to me that it's a fairly academic dispute as whether or not you have a separate claim once you have the relief of a new trial.
Well, we don't think it's an academic claim with respect to adding the condition that requires a certain level of constitutional performance for the defense counsel.
You always have the same level of constitutional performance. This is only going to come up as a particular problem if for some reason the lawyer says exactly the same thing in closing as the prior lawyer did, and I don't anticipate that happening.
Well, this actually happens in ineffective assistance of counsel claims in other contexts where the State court has the power, for example, to conduct a colloquy with the defense lawyer, to probe what the judgment is that has informed the defense lawyer's representation, what the defense lawyer has done, what the defense lawyer plans to do, and, of course, the State has the ability to object and move for curative instructions if the error recurs. But the really important point is that if the error recurs, or if the State fails to fix it, the remedy is immediate release, which we should all agree is a dramatically expanded form of relief, which would necessitate a cross appeal. And
Mr. Oldham, some of my questions to your opposing counsel suggest that ineffective assistance of counsel is mistake by mistake, that there are here 3 claims of ineffective assistance, not just one. Maybe that's so. What do you do with this case where the trial court finds 2 instances of ineffective assistance? The State agrees that those 2 are valid, but appeals on the ground that it was harmless error, that the cumulative effect of those 2 mistakes was not enough to change the outcome of the trial. The defendant, on the other hand, wants to raise the issue that there was indeed a 3rd instance of ineffective assistance, and that if you combined all 3, there would have been sufficient harm to enable setting aside the verdict. What do you do with that case? There the 3 separate instances have sort of been combined into one, where the issue is the harmful effect.
The answer, Justice Scalia, would turn on the particularities of the 3rd error of the hypothetical. That is, if the 3rd error was sufficient to push it across the line of the Sixth Amendment and the deficient performance standard, then that would be the contours of the ineffective assistance of counsel claim.
Okay, so you would allow that one to be raised without a cross appeal.
But it would
so long as it would, or at least so long as it's argued that would produce the incremental effect of reversing the judgment.
Yes, we agree with the Clarence Darrow hypothetical from the top half of the argument, which is that you measure the constitutional error based on where the lawyer's performance transgresses the bounds of the Sixth Amendment. And so if in the hypothetical, if that happened to have been on the 3rd error, then that would be the contours of the ineffectiveness claim. To return to the Chief Justice.
Well, before you leave that, I thought that your opposing counsel said that did happen here. It was that you did raise a question of whether there was enough prejudice, and therefore they were entitled to bring in the 3rd as showing that even if the first 2 weren't sufficient, the 3rd made up for it.
Justice Breyer, we disagree with that characterization of what happened in the court below. What happened in the court below and in the district court was that Petitioner raised 3 allegations of deficiency. This is how he characterized it in his own certiorari petition to this court. 3 allegations of deficiency, each of which, standing alone, both transgressed the bounds of the Sixth Amendment and was a prejudicial error. We fought back on 2 because the district court had granted 2, and those were reversed in the Fifth Circuit. He raised a 3rd independent error. And if he wants to add that 3rd independent error to the conditional release order, that is, he wants the State to be held responsible and a constitutional error imputed to the State sufficient to command his immediate release upon failing to fix it at a second trial.
First 2 were thrown out on the grounds that there was no error, right?
That's correct.
Not on the ground that the effect was not harmful enough to warrant setting aside the judgment.
That's correct. They were under AEDPA. That's correct. And although the State did brief it
Counsel, what do you do with the COA? I mean, however we rule, we may be creating headaches, okay? Petitioner wins on 2, and he loses on the 3rd issue, the closing summation. Does he have to then go for the COA? He can't wait for you to appeal and then make that decision, can he?
Well, under our view, and under the hypothetical given on the top side of the argument, he could cross-appeal. And that actually, and of course would have to get a COA. But that's
cross-appeal when there's no appeal?
He could have taken the first appeal.
He could not have taken an appeal. Only the State could take an appeal, right?
Our view is that on this particular judgment, he could have taken the first appeal. And that's incredibly important because it would give him an additional protection if there was a second trial. In particular, he could get a federal court to say the Sixth Amendment demands this level of competence.
Where does the statute or the rule talk about somebody who loses on a particular claim but wins the judgment. I thought, I'm looking at the order. The order is on page 33 of the appendix, and it doesn't say anything about Spisak or about, what was the other? Wiggins. It just says the order is 3 choices: release him from custody, or give him a new sentencing hearing, or sentence him to a term in prison. That's it. That's the order that we're reviewing.
That's correct, Justice Ginsburg, but it must be read in the context of the entire opinion. As we pointed out in footnote 6 of the red brief, this Court and other federal courts often write their conditional release orders differently to say, for example, as Judge Pollack did in the Lamb case, these particular errors have to be fixed. And everyone seems to agree that if the judgment said these particular errors have to be fixed, he could have taken the first appeal or he could take a cross appeal.
If he could take this first appeal, how does it work? That is, it seems to me that I've seen lots of petitions in habeas where an incarcerated person will bring up 40 arguments. Now, suppose that he loses on 39 and he wins on 1 and he gets his new trial. And the court, the prosecution says, fine, we'll go ahead, we'll give you the new trial. Is the lawyer then supposed to appeal his 39 losses?
Well, as a practical matter, the notice of appeal deadline would be far in advance of the retrial decision.
No, you said he could take the first appeal. So before the new trial goes on, he says, I think I'll take the first appeal on the other 39 that I lost on. Can he do that?
Absolutely. And
well, then a lot of people, not saying they're badly motivated, they're in prison, they might, think this is sort of interesting. I might lose that trial. Let's just see if I can't find a few other grounds here.
It's obviously not a lot of people.
No, I haven't ever heard of that. Have you found examples where that's happened?
Well, as the petitioner points out, there's only 18 of these cases in the Court of Appeals from last year, but a great example.
Wait, have you found many cases where a petitioner won in the district court? There is no state appeal, but he did lose on other grounds, and he decided to take a first appeal on several of those other grounds.
I'm unaware of any, but only because the state often appeals.
Any decision by the federal Let's say he loses on a confrontation clause claim. He wins on the adequate assistance of counsel. He takes the appeal. If I'm the judge on appeal, I say, well, in the new trial, they may not call the witness that you said shouldn't have been called. And you want me to issue an advisory opinion just in case they do. I don't see how he can do that.
Well, it wouldn't be an advisory opinion in this sense. It would say that what happened in the previous trial transgressed the Confrontation Clause or the Sixth Amendment, depending on which claimant lost below, and it would give him a very valuable procedural protection at the second trial.
No, it's superfluous in the sense that it is unnecessary to the judgment. He got the judgment he wanted. The trial was set aside. The conviction was set aside. He got a new trial. And he's saying, oh, there are additional reasons why I should have gotten a new trial. I'm not going to listen to that. That's absurd. You got what you wanted. Now go away.
Justice Scalia, our view of the conditional release order is significantly weightier than that. What we think a conditional release order is, and what we think that this Court's habeas cases demand, is that a conditional release order is a federal court's order on a constitutional claim that says the state must release, that is the actual quintessential habeas remedy, or fix these errors. Never does the conditional release order say you get a new trial.